reports, harmonized report, and so on. If in any one of those reports there is any indication that there was an intention to create some provisions which were eternal clauses or which were not amendable, my Lord, you'll find none. Instead, the Committee of Experts identified only 3 issues which were contentious. And those are found in page 1548. And if specifically I can refer to those contentious issues, page 148, chapter 6 of the report of the Committee of Experts. The first one was system of government, the nature of the executive and legislature, devolution, and transitional clauses. That's all that brought contention. And in addressing those 4 issues, it never went to the people. It went to Parliamentary Select Committee. That is borne out by the documents that we have before you and in this report. It went to the Parliamentary Select Committee in Naivasha, the Committee of Experts, and Parliament itself, where there were attempts to amend the draft constitution, the bill that went before Parliament, and none of it succeeded. And this address, the referendum came only after the political players and institutions of governance, Parliamentary Select Committee, and the Committee of Experts had agreed on a final version in which the Attorney General played a significant role. That is the document that went to the people. Because the document that was in Bomas was not agreed upon. And the Constitutional Review Commission Act of 2008, which reignited the constitution-making process, instead of going to the people, it took all these issues to the organs of constitution-making, which included the Committee of Experts, Parliament, and the referendum. So we must disabuse the people who are trying to say that this constitution was necessarily a product directly from the people of Kenya. It was a political settlement. And I want somebody to show me any evidence to the contrary. That Parliament did not play a role, Committee of Experts didn't play a role. In fact, the Committee of Experts itself, which is an organ of constitution making, the appointment did not just involve Kenyans. It involved non-Kenyans. In fact, the road and the path toward constitution making, which required of the president of the day to constitute several committees, including the Waki Committee, the Cridler Committee, all of them had foreign participation.
If I may ask, Senior, now why you are saying it did not come from Wanjiku, it came from experts, all those that you have mentioned. Then why, what is the criteria? Why did you go back and surrender the power to the people?
Yes, because, and that is a good question, Your Ladyship, in the constitution making process, after the negotiations, it was determined that the people had a role to play. And the theme is there, Article 10, the values and principles, the national values and principles, people participation, in parliament, people participation, and in the referendum. So that all through the process of governance, the concept and mechanism of public participation is important. But I think one of the things that Kenya was trying to do, looking at our neighborhood, that we should never use insurrection or revolution as a way of bringing about constitutional change or bringing an amendment to the constitution. Because Kenyans have been to the streets. Kenyans have suffered violence. And a lot this judgment refers to agenda number 4, how to address long-standing issues in Kenya, which included some of these things I'm talking about. So, my Lord, I may take too much time, but it is really painful at the end. And let me say this, that every opportunity that the people may have to amend the Constitution as sovereign, that to making even one step, the people cannot make. Whereas when Parliament had parliamentary authority and sovereignty, they could do it anytime. But for the people of Kenya, you have to ask yourself many questions. Am I a promoter? Certainly that word is so significant. And we should ask ourselves, why is the word promoter used? And why is there any prohibition in the Constitution? Who is stopped from being a promoter? It's like saying you judges should not vote or be seen voting, because that's an exercise of political rights. So, my Lord, I really believe that in democracies where a referendum is a way of allowing people to participate, to make choices, including amending the Constitution, decisions made by the judiciary should favor the exercise of political rights by the people, not the other way around. And finally, my Lord, I just want to say this in conclusion. If you look at the orders that the court made, and we agreed by all of them, I want your lordships to tell me if this is not lawmaking. Paragraph 784 in the judgment. It's paragraph 784. If this is not a usurpation of sovereign power and usurpation of legislative authority, the first declaration, a declaration hereby issues that the basic structure doctrine is applicable in Kenya. That is like Hammurabi the lawgiver. The court has pronounced. That is law. That is lawmaking. B, that the basic structure doctrine limits the amendment power set out in Articles 255, 257 of the Constitution. That is the court saying that when it comes to basic structure, forget about 255. Forget about the rights you're given in 255. C, that the basic structure of the Constitution and eternity clauses can only be amended through the primary constituent power. Where is that primary constituent power located in our constitutional structure? Other than the academic analysis that the judges have done, and I'm saying that there is no such constituent primary constitutional power, because the people themselves, they have said that they'll exercise their authority or sovereignty through the Constitution, which means they respect the organs of the Constitution. And, my Lord, one could go to some of the lawmaking roles that this court took. And I see so many times in the United States of America, when a matter arises, even the Supreme Court, they say, go to the Congress. Go to the Congress. If these limitations are not respected by the court, how would Parliament respect those limitations? And I pray that we live by the true word and spirit of the Constitution, and not begin to put ourselves in a situation where, if I ask some of the very senior lawyers here who have practiced with a long time, and they could have better judgment than people out there, could you tell me, why do you find the eternity clauses in the Constitution of Kenya? We have to come back to you to tell us. And the court says that you have to do it on a case-to-case basis, something like an eternity clause, or basic structure, which is an amendable. That cannot be a matter of intendment. It cannot be a matter of contemplation. It must be in a written constitution. That is the value of a written constitution. So that the Constitution in its application and enforcement is predictable, is certain. So I do pray that you allow this appeal and sit down to my little friend, Mr. Paul.
Yes. Senior, I'm just wondering, this the basic structure doctrine and the so-called eternity clauses. I think some scholars think that the term is a bad term, eternity clauses, but I think they agree on the meaning. My question is, how long has it been in the courts? I mean, other than perhaps this may be the second time, it's been perhaps third time. It may have been mentioned in passing in Joya. Yes. But the Indian case was decided almost 50 years ago.
Yes.
And if you trace it, that thought has been exported to almost every region of the world. So, question is, do you think would you say that the Kenyan, this particular decision is really an outrage of sorts, creating something totally new that has never been seen before?
I think it's good judicial literature, very compelling. But in terms of the Constitution that we have, it stands on no pillars. My Lord, I also wanted to say, in conclusion, because you have mentioned that this basic structure may be applied universally, I think really it is not. And if you look at where it has been applied in the Asian subcontinent, even looking at the countries themselves, other than India, Pakistan.
Pakistan rejected it, actually.
Yeah, eventually. Or Bangladesh. Is that the league where we are? And historically, we can understand the meaning, why they would want quickly to jump on an issue like this. In Pakistan, where presidents are assassinated and killed, I shiver that we go that direction after so many wars in this country to have a definitive document. And because Justice Kiagi has asked me this, I was going to say it at the beginning, totally unrelated to what you have said. I am a member of FIDA, I don't remember, and I've argued cases for them. So I'll say this with a lot of respect. There's the court's rendition of what they say is history. A lot of times they say, really, what you make of recorded history is not really by the maker or the participants, it's by those who write it. And my Lord, I would invite you in the Bible. There's a lady called Jezebel. If you read her story according to the Bible, she was a vile, satanic woman. But if you read other accounts of Jezebel, they are very, very good accounts. Of a strong lady, believed in the religion in Phoenicia, because she was married to an Israeli, a Jew, Ahab. And asked the court also to read about Marie Antoinette. Her story is terrible. But if you read the correspondence between her mother and between the ambassador and her mother, Emperor Theresia, you'll get a completely different picture. So these judges, they gave us a story that if you don't try to go into the real story, you'd think that politicians are evil. They never really had anything to do with this. But the record will bear out that at every stage in constitution making in Kenya, it's only when we came together, including politicians and presidents, that this process went ahead. And without it, it could not happen.
Right, Senior Counsel, I hope you're watching the clock. I'm remembering that your time is halfway gone.
Yes, may it please my lords, my lady. My name is Paul Mwangi. I'll be doing the rest of the presentation regarding basic structure. First, I want to add to a clarification on something Justice Kage had asked. This is in relation to a parliamentary initiative, popular initiative that begins with a general suggestion. And I answer this question because sometime in 2014, led what was the first attempt at amending this constitution by popular initiative. And we tried to do it by way of a general suggestion. And the protocols that were given to us by IEBC then is that we first told IEBC what were the general suggestions we had. For example, one of the general suggestions was that we should increase the amount of money that was going to the counties. We wanted to create a ward fund. We wanted to give it so much. So when you go to the public, you go and collect your signatures with those suggestions. And that is what you propose to the people. But after they have given you the signatures, when you go to IEBC, they now tell you you need to reduce those suggestions into a bill. So you now turn it into a legal instrument, which you now forward together with your signatures. And that legal instrument is what IEBC is about to send to the counties. So the general suggestions are made to the people who you want to support. But the second thing I'd want to comment also is that the million people raise the bar for you to show how serious your question is. So that not every suggestion can be taken to the counties. Because by that time you start having to spend public money to process your proposal. So before any commitment is made for any proposal that is done, you'd have to literally prove that you have a serious suggestion, and therefore you're supposed to prove that you have at least 1 million people who believe that they would want to support what you're saying. That said, my lord, I want to first begin with what my learned senior talked about, the skewed history that was given about constitution making by the 5-judge bench. And to say first that that skewed history was given deliberately so that it can support the basis on which you can read a basic structure. Because without reading the Constitution as a direct product of the people, you have no justification of reading basic structure And it was also meant to run away from the fact that if you look at the history of constitution making, of Constitution 2010, as my learned senior said, it was a product of a political negotiation. And I went through where the court got its history from, and it gave 90, I looked at the footnotes, and it gave 90 footnotes on where it had derived its facts. The largest footnote of where they got their historical facts was by an article by Jill Cottrell in the Ashpal Guide. The article is called The Role of Constitution Building Processes in Democratization. It had 15 footnotes. The second source was another article in the Yale Law Journal called Designing a Constitution Drafting Processes, Lessons from Kenya 2007, by a lady called Alicia Bannon. It had 6 notes. And just as another example, there's an article by James T. Gadhi, A Popular Authorship and Constitution Making, Comparing and Contrasting the DRC in Kenya. It had 5 footnotes. On contrast, the report of the Constitution for the Review Commission, which is the actual now official history of what happened, had 4 footnotes. And the report of the Committee of Experts had only 8 footnotes. So, and my view is that they were taking only the history that seemed to serve the purpose. If you look at the judgment, my Lord, it also showed you the second point that I want to make, that even the view of that history was biased. If you look at page 190, sorry, my Lord. For instance, in paragraph 408, there is the attempt to, in paragraph on 107, there's a paragraph written as 107 on page 190. This is on the volume 1 of our bundle. On the 5th line, the court says that after that was achieved, shortly after independence, the political elite, driven by greed and selfish ambitions, jettisoned the concept of constitutionalism, implementation, and instead embarked on and succeeded in making...
Please give us the paragraph.
But it's paragraph 408 from the beginning on page 190. Should be on the judgment. It's page 151 of the judgment itself that's indicated at the bottom. But if you're looking at volume 1 of our bundle, it is paragraph 1. I mean page 190.
Yes.
And my point of talking about all amendments as driven by greed and selfishness, the point is that one of the first amendments we made to the Independence Constitution was so that we stop being a dominion of England and we become a republic. So one cannot always look at all these amendments as the court says, driven by greed and selfish ambitions. It could really not have been greed and selfish ambition to try to be a republic and move away from being a dominion of the Queen of England.
I know what? I'm not seeing it.
My lady?
I'm at page 190. I'm not seeing it.
Of volume 1, my lady?
What paragraph of the judgment?
The paragraph of the judgment is 408.
408.
Yes. It is quoting a case called Council of Governors and 47 others versus Katiba Institute.
I'm looking for greed. Can't seem to find it.
On the next page, there should be a paragraph that begins with 107, my lord. Which would be page 150 of the judgment.
It's actually 190.
There seems to be a problem with the numbering. 107, you go to 107. What then?
No, 107 is now, yes, 107 is the paragraph in the judgment that is being quoted.
It's
Yes.
a quote.
So you're looking on the fifth line in that paragraph indicated as 107. And the point I was making is that there is a definite bias in the way the court was looking at its history. Again, if you go to page 195, this paragraph 422 of the judgment, the court starts paragraph 452 and says that as aforesaid, Professor Guy wisely delayed his official appointment. I do not know how, without bias, the court would come to the conclusion that that was necessarily wise. But my point, my lord, is that the history that was done, as my learned senior has said, was a history that was being quoted so as to remove the aspect that this constitution was a politically negotiated document, try to remove the aspect that the closest we came to a constituent assembly was at Bomas, and that the product that came out from Bomas was defeated in the referendum in 2005. And that by the time we kick-started this process again in 2008, Bomas was just a source document. And if you read the report of the Committee of Experts, they were looking at many different documents so as to come up with a draft constitution. And there were very many other processes that involved politicians, and as I will be submitting later, some of the things that were being viewed by the court as part of the basic structure. For instance, the presidential system of government was actually given to us by politicians sitting in Naivasha. And you cannot include that and say that it is part of the basic structure, because it was not even ever at Bomas, never at any process was agreed on one day by politicians in Naivasha. But let me go now to, I will not go through what has been said before, so I will put my own explanation of some of the concepts that have come. First, I want to deal with the issue of the eternity clauses. And as my learned senior has said, that an eternity clause is an actual clause. And you will find it in the Constitution, and so expressly said. And what I wanted to emphasize was that first, what they call eternity clauses, wherever you meet them, they have a history. And my learned senior gave the example that France has an eternity clause that says that you cannot amend and change the republican nature of France. I looked through the history of the experience of France with systems of government and why France would have wanted to do this. And what I found is that France started in 1789 at the time of the revolution with an absolute monarchy. After they overthrew King Louis XVI, they called him back again in 1970 and made him into a constitutional monarch. He was overthrown 3 years later. They formed the First Republic. The First Republic was overthrown by Napoleon, who created an empire, which was there between 1804 and 1815. Napoleon was overthrown, and they brought back a constitutional monarch between 1815 and 1848, which had three kings, Louis XVI, King Charles X, and Louis Philippe. They were removed, and they now adopted the Second Republic from 1848 to 1852. That republic itself was overthrown again by Louis Napoleon III, who created the Second Empire. Then the Third Republic came and overthrew Louis Napoleon, then was there between 1871 and 1940, which was now one of the longest serving systems of government. The Fourth Republic came in 1944 after the war to 1954, until again Charles de Gaulle decided to give them a constitution, making the Fifth Republic. And the history had been that there were so many competing interests about the nature of government France should have, that France decided to have a clause in their constitution and said that you can never change the republican nature of France. I will give another example.
So, Counsel, your submission is that an eternity clause must be expressly stated in a constitution, and there has to be a history behind that particular clause to inform its inclusion.
Yes, I am saying they are not idle. They are
Not idle.
They are not idle. They are clauses that are there to give practical legal solutions to political problems or governance problems that a country has. The second and last one I wanted to give was that of Turkey, because Turkey has attempted to protect the secular nature of the state. But if you look at what Turkey has been through with religion, Turkey started in the 1st century as when called Constantine the Great converted to Christianity. It spent the next 1,000 years being the center of Christianity in the world. Then the Christian empire in Turkey was now also overthrown I think in the 11th century, and the Muslims came in, and they controlled for the next 900 years, and Turkey again became 100% Islam, and became the center of Islam also, as the only Islamic caliphate. By the time they were coming to modernize, with the ambitions of Ataturk, one of the biggest problems Turkey was having is how do you protect this secular state, knowing very well that the state is founded with a very underlying religious overtone. So they come up with a clause that protects that part of the state, because you know that if you leave it to amendment, it will be overthrown. And the eternity clauses are not always just permanent. There is a case of the US when they formed the first constitution, because when the US was signing the first constitution, one of the biggest hindrances in forming the union was the issue of slavery. And they had to agree on a temporary eternity clause. That was, I think, in Article 15, that says you could not amend the constitution to remove slavery. And that, I think, went on until they were not able to pass what became the 13th Amendment until the year 1865. That's when they were able to remove slavery. But during all that time, slavery was protected by an eternity clause. So one of the simplest questions that the court could have answered when faced with is that does the Kenyan Constitution have an eternity clause? It does not have. And it was wrong for the courts to treat eternity clause as if it's a theory. And the mistake also came with, if you look at page 43 of volume 1, the eternity clause is referred to in the prayers of the petitioner as if it's a theory. Because in the first prayer they said, a declaration be and is hereby issued that the legal and judicial doctrines of basic structure, doctrine and theory of an amendability of eternity clauses, and doctrine and theory of constitutional entrenchment clauses. When it comes to eternity clauses, they are not theories. They are direct constitutional provisions, and Kenya does not have one. The second issue I want to comment on is the issue of the basic structure doctrine. And I want to state here, my lords, my lady, that the court mixed up all these issues as if they all mean the same thing. And therefore, as you read, you find yourself falling over yourself on when you're dealing with basic structure and when you're dealing with eternity clauses. But there are actually three very different things. There's eternity clause, which is extremely distinct from the issue of basic structure. And there is basic structure also totally distinct from the issue of amendability. The basic structure doctrine can only be understood by looking at the case of Casavanadra. And for one to understand the case of Casavanadra, you have to first, or to understand its applicability, you have to look at what the court itself in India said when employing this doctrine. And I'll read this quote. And the court said that I must interpret Article 368 in the setting of our Constitution, in the background of our history, and in the light of our aspirations and hopes and other relevant circumstances. No other constitution in the world is like ours. No other constitution combines under its wings such diverse people, numbering more than 550 million, with different languages and religions and in different stages of economic development, into one nation, and no other nation is faced with such vast social and economic problems. So that is one of the bases in which the court was finding the pressure that it has to adopt a doctrine that would stop Parliament. And the idea is that the Supreme Court was literally saying that if you look at India and its diversity, you cannot sit as a parliament of 500 people and feel as if you represent India is too diverse to be represented by that number of people. That is one aspect on which the court was coming from. And if you look at the numbers in India today, there are 1.3 billion people, second largest country in the world. They have over 450 languages. They have over 3,000 castes. They have 28 federal states. I think almost each of them is larger than Kenya. So by the time a court in Kenya wants to adopt Casavanadra, it must want itself the basis and the country from which this doctrine had been taken. But the second thing that one is supposed to warn itself is the circumstances also in which that decision was made. And Casavanadra also has what I'll call a dark past. Well, in volume 2, I will leave it for your lordship's ruling. In volume 2 at page 728 is a book written, The Indian Supreme Court and Politics. And one of the things that the Indian Supreme Court had decided in the light of the Indian situation was that they were going to be a political institution and that they were going to enter the political field. That book is written by a Professor Upendra Baxi. I just want to read one paragraph in the introduction. That paragraph is on page 731 of that bundle. And the paragraph says, and this is Professor Baxi saying, and this is written, my lords, in, I'll get the year of publishing. This is 1979, that's when the introduction was made. So on 731, the second paragraph of that page, and it said, and yet what has to be said in this book has to be said.
Mr. Mwangi, the copy I've been given is missing that particular page.
I'm told it's the Case Digest, Volume 2, Case Digest.
Excuse me? Is it not this?
You can continue, Mr. Mwangi.
Yes, the writer is capturing what was the attitude of the Supreme Court of India then, when it was passing these judgments. And it says, and what has to be said in this book has to be said. It has to be said because it is true. We may or may not want a government by judiciary, but in certain respects, we already have it. We may or may not want justices to have the power to make law and even the Constitution, but they have it. And what is more, they exercise it readily and regularly. We may or may not want them to be seen exercising this power even when they actually exercise it. But the truth is that the executive of their power is writ large in the corpus of decisional law. So the Indian Supreme Court is making the case of Casavanadra also within a political context. And it is not the first time that this doctrine came up. This was actually the third time that this doctrine was coming up in the Supreme Court of India. But the reason that it was getting accepted now were two reasons. One, because the institutional wars between the Indian Supreme Court and Parliament had gotten to a stage where Parliament, the Supreme Court was also looking for any way to cramp down on Parliament. But in two previous cases, and that is in our submission, the court has said that the power of Parliament was unlimited. And even several paragraphs within Casavanada also seem to keep saying that the power of Parliament to amend the Indian Constitution is unlimited. And my point is that it is a decision that one cannot take from India and try to implement it in Kenya, because the circumstances are the same, are not the same. And in Casavanada itself, one of the things they could not agree on among all those judges is also what is the basic structure of the constitution in India. Some people thought that that basic structure would be found in the Bill of Rights. Others thought it would be found in sovereignty. So even like the Kenyan case, the court was being unable to find out where the basic structure of the constitution is. And the case, if I refer to page 218 of volume 1 of the record, the court itself, and this is on line 21, it says an exhaustive list of what the specific provisions of the Constitution are amendable or eternity clauses is not advisable to make in a vacuum. So even the court, as it was putting the basic structure doctrine on Kenya, could not tell you any aspect of the Kenyan Constitution that one could say was unamendable. Now, I'm told my time is running out, so I want to go straight. But only one last thing, my lords and my lady, that the history shows that the actual doctrine of an amendability had come from Germany by a writer who, having witnessed the power that Hitler had over parliament, had written an article and propounded a theory in which he had suggested that powers of amendment should be limited. And then he happened to go to India to give a lecture, and one of the people who attended that lecture was an advocate called M.K. Nambia, who was at that time involved for the petitioners in the case that came before Casavanada Golaknath. That's when he first introduced the concept. And the Supreme Court rejected it. But by the time Casavanada comes up, the political war is so hot on the Supreme Court that they were looking for any reason to justify their clamping down on Parliament. And there were many wars that happened after that, which will not relate for now. But the third last thing I want to ask to deal with is the issue of unamendability. And unamendability is a jurisprudential concept. And it is an item of jurisprudence that some, what I would call New Age scholars, are trying to urge on the world to say that there should be some limitation to be decided by the judiciary on when people or what people can amend in a constitution. One of the people that was quoted extensively to the lower court and will be quoted to you is Professor Yanif Rosnay, who is one of the lead proponents of this. And he captured, what will be quoted to you is something that he wrote in a PhD thesis he wrote in the year 2014 when he was applying for his PhD in the London School of Economics. And then it was called Unconstitutional Constitutional Amendments, a study of the nature and limits of constitutional amendment powers. And it started gaining publicity when it was published by Oxford University Press sometime in late 2016. What I would want to comment about this first is these concepts are not being employed elsewhere. In fact, our own neighbors have rejected it. Uganda has rejected it. Tanzania has rejected it. Every African Supreme Court has rejected it. For some reason, Kenya has decided it is okay.
Perhaps, Mr. Mwangi, to be fair, in the Tanzanian case, you recall the High Court accepted it, but the Court of Appeal reversed. And I'm sure that's what you would want us to do here.
That is what we are praying for, my lord. The idea is, in fact, that is one of the things that the Ugandan court said, that these ideas are so new. Nobody knows what mess they are going to put a country into. Nobody knows what constitutional disorder is going to come to the system when we start employing this. And the Ugandan court was more like, if it's a good idea, we will find out. But you get the feeling as if ideas, foreign ideas, are being experimented on us. And I don't know why it doesn't get offensive when it comes to law, because we were recently very offended when vaccines came out and they said they are first going to bring them to Africa to try them and see whether they are safe. But that is exactly what is happening. That new constitutional ideas that can bring serious constitutional crisis in this country are being brought to us, where the countries from which they come will not touch them.
I'm just wondering, Mr. Mwangi, whether you're trying to make a connection between vaccines and the idea of inoculation that is in the judgment.
No, my lord. I'm just saying that it would have been a good thing for the court for the High Court to have taken that in mind, that we actually have no country in which we know how this is going to play out, and that there's no hurry. But my other problem with it is a more theological problem. And and we brought that to the court, and I will read that quote to you. But we asked the court, we took it back to theology, and we asked them that the question is asked whether man is made to serve law or law is made to serve man. And my judge, Justice Kiaga, did ask my senior, Oraro, whether that is an aberration. And for me, yes, that is an aberration. Because the day we get to elevating the law of man to almost being a religious law, in fact, at the High Court we say that is the height of idolatry. Because there is only one law that man cannot change. And that would be the law of God. It's the only one that you must obey. Anything else that is a law made by man, cannot conceptualize a situation in which we come up with an idea that cannot change, and that we are going to serve it regardless. I'm trying to get the quotation that we read. And that it becomes something that we must serve. But that is what is being done with constitutions, and that is what is being done with the doctrine of unamendability. That the moment you put up a constitution, that constitution becomes bigger than you. You can no longer change it. The lower court came up with a system which they said is a system we can use to amend the constitution. In truth, it is not workable. But I will close. I am seeing my time is up. But I will close, my lords, by reading the quote that it inspired on page 1117, our old submissions. My junior will tell me which band that is.
Just go on, in the interest of time, counsel.
I will finish by reading it, and what we told the court is this: that there cannot be any legal reasoning, however well expressed, and there cannot be any constitutional theory, however well woven, that can justify the recognition of a power over the free will of men and women. Such power can only be found in theology, and none of the monotheistic religions tolerate the creation of any power of a man in partnership, in competition, or in replacement of God. A secular court must repudiate all endeavors to set up such a power. The concept of the spirit of the Constitution cannot be perverted into a legal theocracy that creates a higher consciousness above man that is found outside the written text of the law. Such a theocracy invariably makes the judiciary, rather than the clergy, the conscience of the people, and exposes the nation to the perilous interpretation of every judge of what that legal theology is established to be followed. To read into the Constitution 2010 a power over and above the free will of the people of Kenya, whereas that Constitution is emphatic regarding the sovereignty of the people above all laws, including that Constitution itself, is equally emphatic that the concept of state and religion is forbidden, would result in a legal aberration that can only be described as idolatry. That is all, my lords.
Thank you very much.
My lord, I am told it is in volume 3, page
Volume
One.
3? Volume 3, page?
1117.
All right, thank you very much. It is now 4:30,
Now it's my learned senior.
almost 4:30, that's what I'm saying. That is Mr. Atienda Molo.
My lord,
You are saying it is...
Mr. Otendia Molo was to
Ye-
come in for the next.
Yes, now, Mr. Atienda Molo, how long will you require? Because it's coming to 4:30. We had said that we will be adjourning at 4:30.
My lord, my ladies, seeing that it's only 2 or 3 minutes to 4:30, and given your earlier directions, we are happy to start tomorrow morning.
So how long will you require tomorrow morning?
My lord, my lady,
Because today, the BBI secretariat and Honorable Raila Odinga have taken what? Just about 2 hours?
yes, my lord, of the 2 hours, we still have 43 minutes. And we had made a special plea at the beginning that the learned lawyers, advocates for His Excellency the President, had agreed to donate to us 30 minutes. So it was our hope that if the court would indulge us, then we would have that additional 30 minutes, so that between Senior Counsel Lucy Kambuni and myself, we will then cover the remaining 4 subjects within that time.
So how long will you require between yourself and Senior Counsel Lucy Kambuni?
That would bring it to exactly 73 minutes.
Okay, so we adjourn, then we adjourn until tomorrow. We adjourn until tomorrow. Yeah. Okay, we want to adjourn until tomorrow morning, 9 o'clock. And I want to request Mr. Tienda Molo and Senior Counsel and Senior Counsel Lucy Kambuni to take 1 hour tomorrow.
My lord, sorry, my lord, out of courtesy, I wish to inform the court tomorrow. I'll be going to bury the man who Senior Hamino had attended the funeral service, Mwangi Stephen Muridi, and I will therefore not be in for tomorrow's proceedings.
That's fine. You have already done your part this morning.
Mr. Blaine.
I mean, this afternoon. Thank you. All right.